Good evening. This is Rahul Reddy. Along with me is my business partner, Emily Newman. We do bring in immigration updates every week from 5 p.m. Central Time to 6 p.m. We do live questions live from Houston. Emily, what do we have today to discuss?
Yeah, we want to talk about the Iran war and how it changes or impacts Trump's immigration policies, how much worse it can get. We're hearing a lot from Iranians, particularly who are subject to the USCIS adjudications pause. But that technically is not just for Iranians. There's 39 countries that are subject to that. So it has nothing to do with the war itself, even though that seems to be what people are thinking. So there's a lot more going on, but there's a lot that this war can do when it comes to business immigration. So we'll talk about that. And then we'll talk more about the $100,000 fee for H1Bs that was part of Trump's executive order or presidential proclamation from September 2025. There still seems to be confusion about who it applies to. So we'll try to clear up some of that confusion. And visa screening is, already at a very high level, this idea of extreme vetting. It is increasing by the day. We now have lots of visa classifications that have to share their social media and make it public. They've added a bunch of new categories to that. What does this mean for all US visa applicants? And then lastly, we are hearing that some H1B and H4 visa appointments are opening up and becoming available. But should you take USCI or the Department of State up on these and actually travel if you are in the US, or should you stay put if you are here?
First of all, about the Iran war, though, why are the immigrants attached? As Emily pointed out, it's only one country that should be, and that's not a significant country that we get immigration, either non-immigrant visas or immigrant visas or H1B. However, the war is going to affect everybody. As Emily pointed out, they already barred 39 countries to enter into to get a visa stamping, to get the visa extension, to get the green card. They put a pause on them until they decide what to do. And if there is any recession that will happen, whether it's because of the war or other financial things, though, I know whom the administration is going to blame, Emily. Of course, they're not going to blame Iran because they're going to say, "Well, it's not. It's the immigrants that caused all this one." And it's the immigrants that will get the short edge of the stick, Emily. That's what is going to happen. It's going to get much worse if this war is going to escalate and if it's going to turn into high oil prices, and that may tend to get into recession, or if the stock market falls down, that may tend to going recession. It is going to affect the immigrants. I have seen this two times, Emily, while you have seen probably one time after you became an immigration lawyer. That is in 2008. If you have seen that, how many number of H1B applicants we filed in 2007 in the lottery quota, where we have to file on the first day. In 2009, though, when we have to file in the lottery, which is on April 1st of 2009, it was almost down by, I think so, it is like less than 10% that we filed in the lottery in 2009. And the lottery was open in 2009 and 2010. And later on, the lottery went into the picture, though. So, imagine filing an application 10% of less than 10% of the time. I would say it is only 5% of the H1B we filed in the lottery in 2009 as compared to 2007. And so that is the difference where we feel that the recession may affect the immigration process. Now, getting a new H1B is a tougher job, but also at the same time, getting an extension of H1B will be tougher. Labor certification, perm labor certification is going to be a big problem. So definitely, if there is a recession, then we know who the Trump administration is going to blame. They're going to blame immigrants for everything. They're already blaming immigrants for everything. They don't blame immigrants for increasing the economy. When the economy goes up very high, it's only their skills. All this NVIDIA, founded by the person who's not born in the United States. We have Tesla, who's founded by not born in the United States. Google CEO not born in the United States. Microsoft CEO not born in the United States. All these things, they don't give a credit when the economy goes up. When the economy goes down, we know whom they're going to blame. So definitely, we have to watch very carefully. And what are the precautions people can take, Emily, when things are going to come?
Yeah, that's a great question. I think number one is to think about job opportunities. What is your backup plan in the event that you are facing a job loss situation? And making sure that you're not ever in a situation where you face a job loss after your I-94 has expired and you have something pending. Making sure that you're always filing well in advance, getting the approval quickly in premium processing. You don't want to be in a situation where, the company filed your extension, it's pending, they file it in regular processing, and then 4 months later, it's still pending and your job is terminated. There is not much you can do in that situation versus the person who filed that extension in premium processing and got it approved. And then 4 months later, a job loss happens. Now they have a 60-day grace period. Now they have time. So that would be one of the major things to just plan ahead and make sure you're filing early using premium processing for any extension or renewal or transfer that you have the option of using premium processing for.
One other thing is that always discuss with your family and have a plan B. Now, previously we have a plan B was just to go to India and then come back in H1B later on. That may not be a good idea right now, and then we'll tell you why later on, though. But maybe doing one other master's degree or doing some extra education to get your tools more educated and stay in United States legally, and then probably make yourself ready for the job market, whether it's here or whether it's in India. Emily, $100,000, and we do conduct these live sessions every week, and we also do live Zoom calls every day. We've been doing it from past 14 years. Previously, it was conference call. It's a Zoom call, and a lot of people are confused about this $100,000. And this is what you explained, Emily. And I want to have you clarify that the $100,000 you said it's not applicable if the person is filing the H1B within United States, whether he is converting from F1 to H1, H4 to H1, L1 to H1. You said it's not also applicable for the H1B extension. It's also not applicable. It's not applicable for the H1B extension, H1B transfer, H1B amendment. And it's not applicable if the I-140 is approved and you're extending the H-1B within United States more after you have an I-140 approval. Now, and you clearly said, Emily, that the H-1B $100,000 is not applicable when the people are changing the within United States from F1 or H4 or any other visa status to H-1B. But you said that if somebody is applying for the H-1B lottery from outside this country, the $100,000 is applicable. You said it very clearly. But here is the confusion, though. I already have my H-1B approval. I already have my I-140 approval. Now, if I want to go back to India, I want to come back, is $100,000 applicable?
You already have your H-1B approval. It's valid. You
No,
have a
it's not.
valid visa.
No, I don't. I don't have a valid. It's expiring this month, and I'm losing the job. And now I'm going to go to India. You told so many times in this YouTube that if I have an I-140 approval, I can come back anytime to United States filing an H-1B. And let's say I come back after 2 years. Is $100,000 applicable?
It is, yes. So prior to September 2025, that would have been our, recommendation for many people, is to travel and apply for a new H-1B petition while you're outside the US. You're not subject to the lottery. You can file any time of year. As soon as you get the approval, you apply for the new visa and come back in. Since September 2025, that is no longer an option because when you're outside the US, the company has to file a petition for new employment, even though you're not subject to the cap, even though you're not subject to the 6-year limit. It is still a new petition in that sense that they have to select new employment on the I-129 form because it is consular processing. So any consular processing petition that is filed after September 21st, 2025 does require the $100,000 fee.
That's good to know. And a lot of people are confused that it's only applicable for the quota cases coming outside United States. They are not aware that it's applicable to everybody who is coming from outside the United States. They are filing the H1B for consular processing. It's very confusing to a lot of people when we face these kind of questions. Emily, what is this additional visa screening? I mean, how much more additional screenings that they want to do? What is the purpose of this?
I think the true purpose is just to delay and deny as much as possible to try to keep people outside the US. We've said many times that this administration, with Stephen Miller behind it, does not like any immigration. High skilled immigration, merit based immigration, none of that exists. They want zero immigration. And one way to do that is to slow things down at the consulate. So now their latest plan to do that, if you all remember in December when everyone was traveling for the holidays, everyone on H1B and H4, they created a new policy saying we need to see your social media before we can approve your H1B or H4 visa stamp. They used that as the reason to cancel everybody's appointment and then reschedule them into 2027 if you're lucky. That impacted a lot of people. Well, guess what? Now they've extended that to like 10 other visa categories, R1s, K1s, H3s. I don't even know the whole list. It does not impact L1s and L2s yet, but practically everybody else, they are expanding that social media vetting to. Um, have you heard of anyone's visa being denied because of what's on their social media? I haven't. That tells me that this is all just an excuse for them to claim it's in national security, but just plan to deny or delay as much as possible to keep people outside the US.
Yeah, I don't know of Emily anything else. Recently, the only thing that I heard was that who is considered to be very number one terrorist, Qasem Soleimani's niece or somebody was arrested in United States. I don't know how they did not find out what the issue is in there. We don't know. But as far as my clients are concerned, I have never seen anybody getting denied because of the social media. Does it mean people can oppose the war, support the war? No, that has nothing to do with it, though. They actually intended something else. They are only, that's completely irrelevant whether you support the war, oppose Trump, or support Trump. So that we have never seen anybody getting denied. So some people got scared. Oh, I did some posting saying that Trump is not good in that particular thing, and then they got scared and took an appointment. And you're wasting your time, guys. You're fine. You're fine. You should not have any problem because of that now. But as Emily has pointed out rightly, the reason is that they just want to delay it. And by delaying it, what happens is that let's say you have a job and they delay the things and you lose the job because if you are not going to join the company, they may terminate you. And that's what exactly they want. So definitely the reason for all this vetting process and all those things is just to delay the process. We already know that there are no appointments available for a long period of time for a lot of non-immigrant visas. And this extra vetting process will give them extra time to delay or deny the entire things. Emily, what if recently some people are said that they got some appointments and can they travel to India right now and get their H1B stamping and come back?
Regardless of appointments opening up, if you are in the US, you have no business traveling outside the US in this environment. I mean, we've just given you what the last 15 minutes of everything this government is doing to keep you outside the US, and you're in the US, and now you want to go outside the US. Getting an appointment is the easiest part of all of this. Everything else after that is just because they gave you an appointment, what's stopping them from canceling it? Like they did to thousands of people in December. What's stopping them from revoking your, potentially revoking your visa for some law enforcement interaction that you've gotten approved the visa for multiple times right after they issued the visa? What's stopping them from giving you a 221G, going through administrative processing, saying, oh, we need to take some time to look at your social media? Why subject to yourself to so many risks of not being able to come back? And as Raul said, the longer it takes for you to get the visa and not come back, the higher the likelihood that you're going to lose that job. Once you lose that job, you can't get a new H1B because the $100,000 fee kicks in. So you're taking a huge risk by traveling right now if you are in the US. Now, if you're outside the US trying to get in, absolutely take the appointment and do your best to get into the US. But for people who are here and working, maintaining their status, there are very few reasons why it would be a good idea to travel outside the US and attend one of these appointments right now. Because remember, when you're in the US, you don't need a visa for anything. The visa stamp that's in your passport, you do not need it when you are physically in the US. The only time you need a visa stamp in your passport is on the day you are trying to enter the US. Once you are here, it's your I-94 that controls, it's your I-797 that controls how long you can stay. You don't need a visa stamp if you are physically in the US. So stay here, don't get the stamp, don't travel. That's my rant.
Let's go to the questions, guys. Don't travel outside the country. Don't travel. Please don't. Even if you have a visa stamping appointment, don't travel. Even if you have a visa stamping that's already there, don't travel. Now, there are some questions that came in right now. One of the gentlemen, his name is Tim Song. He got a green card 1 week ago. And he, with all the conditions that are there, is it safe to travel? I'm not going to speak about the war situation, guys, but because I'm not an expert in that. But what I can tell is right now, if you already have a green card, assuming that you already have the green card with you, because you need to carry the green card with you. You said you just got the green card approval 1 week ago. Do you have it in the hand? If you have it in the hand, we have not seen any problem, none whatsoever at all. Unless you have some criminal records that are not regular traffic speeding tickets, and you have any, then you need to check with the immigration lawyer. But otherwise, we don't see any problem in traveling. Same question that is coming from Ero Khan, travel and advance parole. We haven't seen any problem in traveling and advance parole, guys. No, we have not seen any travel in advance parole. If you have any criminal records other than traffic tickets, which most of our clients don't have it, then definitely you don't have any problem in traveling outside the country.
All right. Commentary, it says, my wife and I both have EB2 I-140s approved with different employers. Her date is current. Should we both file with each other or just her? Her employer is covering the 485 costs, mine isn't. Well, if her date is current first, absolutely both file under hers. If your date becomes current later and your case is still pending, you can both file under yours. There's no reason to file separately. The EB2 category does allow for dependents to join in the application, so I don't see any reason to not file together.
It's worth every penny you pay the money to the lawyer of your wife's employer. Believe me, don't even go to the outside lawyer to file the application. Even if that lawyer is charging more money, it's better to file along with your wife. File it, file it, file it.
NCM always says, are there any positive updates on B2 NOID petitions? No, they are continuing to deny change of status to B2 applications that were filed on the basis of looking for jobs, especially when a change of status back to H1b has been filed. They are sending an RFE on the B2 saying it looks like you're using this as a bridge to your H1B, therefore we intend to deny. And then as soon as they do deny that, they send an RFE on the H1B saying, guess what? The $100,000 fee applies because we're going to convert this to consular processing. It is a big catch-22 situation. So for people who are already in that situation, we don't have any good solutions. It's very hit or miss. If you are facing a job loss, we would not recommend B2 going forward unless your plan is ultimately just to be here for medical purposes, for tourism, for visiting family with the intention of leaving, and you actually leave at the 6-month mark. But then to get back in H1B status, the $100,000 fee applies, so we would not recommend that.
Satish Kumar is asking this question. Do you recommend Margarita switch at this point of time by traveling to Mexico? Margarita switch is when people move from H1B to H4 or H4 to H1 without going to USCIS. Um, Under certain circumstances, yes, you can. That is what is called an automatic visa revalidation. Let's say, for example, you have a H1b approved in October, and now you lost the job, and you already have a H4 EAD approval all the way until 2027 December. And you want to switch to H4, you know that it takes approximately maybe 3 months to about 14 months to get the H4 and EAD approved. And you, since you already have a H4 and EAD approval, all you need to do is that fly to Mexico and fly back. Yes, Margaritas, which it's called. And when you fly back, you show them the H1 4 approval, even though you don't have the stamping. Now, this is only applicable if you go to Mexico or Canada, guys. This Margaritas, which is not applicable if you go to any other country. Yes, it is still safe. We still send weekly. I send at least 2 to 3 people out to Margarita Switch or to Margarita things. Had no issues at this point of time. It's called automatic revalidation. Now, the conditions is that if you don't have a visa stamping already available, though, you can still go if you have the H4 or H1 validity. And if it's a H1, you still have a job. If it's H4, you're still married and your spouse has the job, you can go to Mexico. But we recommend flying, not driving, because they don't update the things. And at the same time, though, when you go to Mexico, since you don't have a visa to go to come back into United States, you will have to get a Mexican visa. Now, you don't need a US visa to come back. It's called automatic revalidation. If anybody has any doubt, you can type in CBP and automatic revalidation. You can see what I am telling is true, is where people go outside the country. You know, my wife even jokes with me, you send so many people to Mexico. Why can't I do one thing? Send all these people to one hotel and we'll get some commission from the hotel. No, I don't do that. But yeah, that's what my wife says because I keep sending a lot of people to Mexico. No, we don't do commission based, but yeah, that's something that my wife jokes with me. So many people I send people to Mexico for the Margarita switch and certain other things, correcting the I-94 and other things, guys.
Kunadi Sravan says, we applied for the H1B, H4, and H4 EAD together in premium processing. It was delivered to the USCIS lockbox on March 24th. We did not receive receipt notices yet. Is it normal? I would ask if the fees have been deducted from the account through either the G1650 or G1450 form. If that has not happened, then no, it is not normal. Most likely the applications were rejected for some reason. The most common reason for rejection right now is the G1650 or G1450 payment did not go through for whatever reason. And the whole thing gets sent back. So I would definitely be looking at your timeline for when a extension needs to be filed and potentially refile it as soon as possible if you're facing expiration coming up quickly.
I need some discussion, Emily, on the things. Though recently, there are people showing up at the apartments and the houses and asking, "Hey, where is the public inspection files? You're supposed to put them in the notice." First of all, public inspection files are supposed to be kept by the employer, not by the employee. And it is very wrong for them to knock the door because in the LCA, where the public inspection file is there, is already listed out there. Even though the work location is yours, the public inspection file is not kept there. So they should not be coming in. But my gentle advice to if anybody comes in is that do not speak with them. Tell them that I will speak with my lawyer and get back to you. That's the best thing. Anything else you would advise, Emily? Because these people are very nasty coming into even homes.
Yeah, well, I personally never answer the door at home unless I know who it is. We all have Ring cameras, so don't answer the door. You have no idea who that person is. You don't have to answer your door, and you should not, especially if it's someone who's coming there just to harass you, which is all they're doing. You are not required by law to interact with these people in any way, shape, or form. So just ignore them, would be my advice. If you do happen to open the door, or if they come to you at a place of business or place of work or something like that, you can just tell them, I'm not required to answer your questions. that would be my advice. Don't engage because there's nothing by law requiring you to answer any of the things these people are asking. They're not even asking to see the public access file. They're asking for all kinds of other things that they do not have the legal right to get from you.
Yeah, and just if you happen to, just tell that I'll speak with my lawyer and get back to you and close the door, guys. That's the best thing that you can do. Don't argue with them. Don't speak with them. Don't entertain them. Don't, they're already recording, so you don't make a fun of yourself. So please don't entertain them. Um, my GC card was approved, but I didn't receive an advance parole. Both we applied same time. USA's case is closed. How can I get AP document? One thing that we are noticing right now is that we are filing the adjustment of status with the, of course, green card, advance parole, and EAD. They are approving the green card and they are administratively closing the advance parole and EAD. You don't have to worry about EAD. Once your green card is approved, though, if they approve the EAD, they should not approve it. If they approve it, they deny it. They administratively close it. Either way, it doesn't matter for you. You're in good shape. Normally, they will administratively close it or they will deny it. Either of those situations is not harmful for you at all. You're perfectly all right. You don't have to spend time spending 50 cents to send a notice to the USCIS to withdraw the H4. It's not needed. To withdraw the advance parole or the EAD once your green card is approved. They normally do it by themselves. You don't have to do it.
Mayank says my wife's change of status from H1b to H4 and concurrent H4 EAD is pending since July 2025. Her I-94 expired recently. Can she stay in the US while her application is pending? Yes. Although her I-94 is expired, she is in what we call a period of stay authorized by the Attorney General, or POSABAG. That is lawful presence. She is technically not in any non-immigrant status, but she is legally in the country and she can remain in the country the entire time that application is pending. And I am seeing some of these taking 12, 11 months to process right now.
A gentleman, I don't want to name him, his H4 visa priority date is November 2004. And he had a DUI. Now he has been arrested for the second DUI. What are the chances of getting the green card? I definitely want you to contact an immigration lawyer immediately. One other thing that we advise people is that, guys, use the Uber, Lyft. I don't know what you call. Let's call it as a Uber. Use the Uber. It's not worth the dealing. All these things, guys. It's very expensive. Not just expensive. It's not good for you, your family. Use the Uber whenever you have anything, even if you have just half a half a glass of just beer. I want you to take the Uber. Take the Uber. Pay for it. It's worth. Believe me on this one.
Madhu says, where all should I update my green card status apart from HR? The number one thing that you need to do besides informing your employer is social security card. So up until now, your social security card probably has a restriction on it that says not valid without DHS authorization or only valid with INS authorization or something like that. Once you are a green card holder, you can have that restriction removed. And I do recommend doing that, even though it's not required. The reason is because what we saw during the previous Trump administration, for lots of people who were renewing their green cards, they ended up having no green card at one time when they happened to be applying for a new job, and they couldn't use their social security number, their card, as proof of their lawful status to be able to complete the employment authorization, the I-9 process. So those people weren't able to get new jobs because they were in limbo with their green card renewals. So if you get that restriction taken off, you can actually use your social security card as a valid document for I-9 purposes, in case you ever lose your green card or something like that.
Rajnikant has his I-94 expired, but before his I-94 expired, he already filed the H1b extension. Now his priority date is current. Before filing the 485, does he need his H1B extension approved? No, you don't need the H1B extension approved. You can file the 485 while the extension is pending. Absolutely not a problem. I'm getting a lot of questions with regards to the people who filed the 485 application October 2020 all the way to recently. When their priority final action date becomes current, which most of them became current in March and April of 2026, what are the actions that need to be done? First thing that you need to determine is that which line you are in. Are you in EB3 line? Are you in EB2 line? How do you determine? Most of the people filed the 485 application under EB3 in 2020. When the priority date moved for EB2 in 2022, they applied I-485J supplement in EB2. If that is the case, if the I-485 has been filed, then you are in EB2 line because you filed I-485J and you put EB2 I-140 approval in there. So that's the first thing that you need to determine. The second thing that you need to determine is when did you file the medicals though? If the medicals were being filed before November 2023, they are no longer valid. You need to refile those things. So you have to make a decision. Should you wait for the USCIS to send an RFE and then you want to do it? Or you can do one thing, you can get two original certificates of medical, voluntarily send to USCIS the medicals. The third step that you need to determine after you determine that you are in EB2. If you're in EB3, you need to move to EB2. But if you're in EB2, you don't need to move to again to EB2. You need to determine if the medicals are valid. If the medicals are not valid, file the medicals. Where to send the medicals? That's a little bit confusing because you don't know where the file is. Typically, if there is an interview done, or if your file is in the National Benefit Center, then you can send, I would recommend to send the medicals. Now, not 100% of the time when you send the medicals, it will go to the file and you'll get the green card. But there are so many situations where people unsolicitingly sent the medicals and got their green card approved. Now, if it is in the National Benefit Center, you'll send it to the National Benefit Center. If it's in a different center, you have to send it to the different center. You guys can chat with Emma to see where your file is, and then you can send the medicals to that particular place. Now, what steps you need to do? First, determine EB2 or EB3, send the medicals and prepare the medicals, send it to the address to the USCIS where your file is. After these three steps are done, what to do after this one though? Still, they are not approving the green card. Sue the USCIS. It's called writ of mandamus. You can contact our office at any point of time, or you can make an appointment with Stephen Brown. He's the proper person rather than Emily and me. You can contact him and then he will guide you how to do it. Now, why do you need to do this one? So first is that the reason why you need to do is that you know the priority dates moves forward, backward, forward, backward, forward, backward. You have experience. If I would have said this in 2020, you would have laughed at me. No, priority date never goes backward. It only goes forward. You would not trust me. But now you trust me because the priority date can go back. Because you trust me on this one now, because all the experience that you have. So it's better to get the green card while it's current, because it's better to get the green card for all reasons, so that you can get rid of this channel too. Because I'll be very happy not listening to Reddy Newman every week to find out what's going on. I just want my green card. So better to sue them. And the main question that comes is, oh, are they going to take any adverse action if you file a court case? We have never seen that. Imagine this. We are the guys who are taking you to court every day in our office. If there is anything that happened, they should first shoot us before they go to you. So please, we are right now in front of you. So please, it's right time to sue if your 485 is pending for more than 1 year and your final action date is current and you don't have any criminal record, okay? Except any speeding tickets, not those things. But if you don't have any criminal, we strongly recommend suing the government.
BK says, if we file for H1B, H4, and H4 EAD in premium processing, can we get the expedited processing for all of them? My spouse wants to switch to H4 EAD. No. You can get the H1b and H4 together in premium processing, but the I-765 is now delayed because they need biometrics. We went through this before, but the biometrics was for the H4 because the I-539 required it during the previous Trump administration. Now it's because of the photo, because they want to make sure that the photo that's on your EAD is actually you, so they won't let you send in your photo. Now they have to schedule you for a biometrics appointment to come take your photo so that they can put it on your EAD card. That's delaying the EAD by several weeks just to get the biometrics. And then after that, it could be weeks or months before you actually get the EAD card.
Kumar Shank, 2002, has this question. His final action date is current. He has an advance parole valid until December 2029. Is it safe to travel on advance parole when his final action date is current? What happens if they review the application while he's outside the country? Two things. If they approve it, you can still come back. Absolutely not a problem. You can still use advance parole, or you can have somebody mail the green card if you got the green card and come back into the United States. I've never seen any problem in that. What if they will ask for you the interview? I would definitely want you to take the flight and come back. Don't delay the. There are ways where we can postpone the interview. I want to do that thing. I will take the next flight and come into the United States and attend the interview because I want to get rid of the immigration lawyers in my life as soon as possible. And that's what I did when I was an immigration lawyer's client, and I would still advise the same thing for you.
Satish Kumar says at CBP, they issued the I-94 only up to the passport expiration date, while the I-797 is issued for 3 years. What to do? This is one of the biggest mistakes we see again and again and again is people not realizing that they got their I-94 shortened by CBP because their passport is expiring before their I-797. Now, I'm hoping that you figured this out before your passport expires, before your I-94 issued by CBP expires. Then you have lots of options. You can get your passport renewed, take another trip, come back in, you'll get the new I-94 for the full 3 years at that point. Or you can file an extension at that whenever your passport expires, treat that as your new expiration date and file an extension with USCIS. Those are your options if you see it in advance. For that reason, we recommend everybody, every time you're coming into the US, check your I-94, double check the end date, make sure it matches your I-797. If it does not, if it's shorter because of your passport, make sure you take action before it expires. After it expires, there's a lot of trouble with that. We've had people that try to go to deferred inspection to get it fixed. They treat you very rudely there, sometimes make it worse rather than better. They claim they're going to get you deported, all these things. So we do not recommend that option. Some people will try to file a nunc pro tunc extension with USCIS. We do not recommend that. That is discretionary, and USCIS again and again during the Trump administration says this was not an extraordinary circumstance. That was not your fault. Like they're basically saying this is your fault. You should have known, and therefore we're not going to give you an extension. And oh, by the way, we see your I-94 is expired, so now we're going to give you an NTA because you're unlawfully present. So don't do the nunc pro tunc. There are options. Definitely speak with an immigration attorney who can guide you on that. Because it is fixable, but the best way to fix it is before it expires.
Ankit, I received my green card from Facebook. I received my green card a month ago, but my wife's green card application is still pending with no RFE and no documents required. Please advise. Depends on how long your wife's application has been pending, though. If it's only pending from 3 months, then I would just tell you to wait. But if it's pending for more than 1 year, the final action date is current. I want you to sue the USCIS right now. Don't delay it. We have seen a lot of cases that were being filed in the month of November onwards, all the way to even February of 2026, November 2025, already getting approved in EB1 or EB2 if the final action date is current. This is the recent filing cases. The old cases, they have been pending, and they're, nobody's there to visit that file. So we need to activate that file. And sometimes to activate that file is just to sue the government. It is not that costly to sue the government in the federal court. And even if it is costly, if you say that, yes, it's too much costly, I would say it's worth because really it's a miserable being on the non-immigrant visa as compared to green card. Believe me on that, guys. I have been in a non-immigrant visa. Now my situation was quite different at that point of time. The green card was very faster. Right now it's more frustration, so it's worth spending the money to get rid of the non-immigrant and get the green card, guys.
Sahil says, have you heard anything about H1B visa stamping for extensions getting approved in Mexico for Indian citizens? If one has to travel due to a family emergency, would you recommend this? So it's funny that you mentioned that because I've had like four different people tell me that they know somebody that got their visa this way. I have yet to see a visa for somebody issued in Mexico for an Indian citizen unless they were actually residing in Mexico or a permanent resident there. So no, I think that is a rumor. I think that's fake, or maybe they're lying to the Mexican consulate and saying they live there in order to get the appointment. I don't know, but it is not allowed. I mean, it's very clear from the Foreign Affairs Manual, State Department. Third country national processing is not an option, especially for Indian citizens.
Bhupesh Kanyal has this question. My priority date is current again. Yes, we know what the story again means, that it was current before, it went back, now it's back again. Previously, they have issued an RFE, and based on that RFE, I did submit the medicals in September 2022. Should I wait for the RFE for new medical or better approach, file the medical along with the supplement J? It's up to you decide if you want to submit the medicals along with the supplement J or not. But if I were you, I'm going to submit the medicals. 485J is optional, but medicals is must, because here's the thing. If they don't receive the medicals, the officer cannot legally approve your case. I mean, there are some errors, sometimes they do, but they cannot approve it because it expired. So that's the reason you have to send the medicals to the USCIS. You have to make it easy for the officer, guys. One, if there are multiple files, they see one file, medicals have expired. They see one file, medicals are there. Let me open this one. I'm going to approve this case. That's how the officers behave. Don't make that guy work hard, because the more you make them work hard, the more problems we're going to get in.
Ranjit says, my I-94 expired. Before that, I applied for my H1B extension and it's in progress. Now I'm in the process of applying for my I-485 because my priority date got current in April. Is it a must to have the H1B approved before filing the 485? Kind of. So employment-based 485s always require that up till the day of filing the 485, you demonstrate that you are maintaining a non-immigrant status. You are currently not in a non-immigrant status. You are in a period of stay authorized by the Attorney General. Your pending extension allows you to work for 240 days, but you are not in H1B status. If you file the 485 in this situation and your H1B extension ultimately gets approved, you're fine, no worries. But if you file the 485 in this situation and then for some reason your H1B extension gets denied, the 485 does not protect you. The 485 will also get denied because you failed to maintain status, non-immigrant status, H1B status up till the day of filing the 485. It is retroactive in that kind of situation. So better to upgrade it to premium, get it approved, and then turn around and file the 485.
My current H1B is expiring. H1B and H4 is expiring in February 15, 2026. However, EAD is expiring in earlier October 28, 2026. Yes, you can apply the extension though. You can apply the extension. That is the best option. Now, here is what people say. Can you apply more than 6 months before? We have done several times, had no issues. Now, if you think so, I mean, you never know. Immigration can always do one thing. So let's assume that your H4 and EAD is expiring in 2027 April, and your husband's H1B has been extended all the way to 2029. Either they did an amendment plus extension or you transferred to a different company. Do you have to wait for 6 months to file it, or can you file it right now? We strongly recommend to file it right now. And if you think so there is a problem, you can do one thing. You can file it right now, and you can file one more time 6 months before. The immigration won't object to that one. because in the first application, you're still saying the husband is the same. Second application, husband is the same. So nothing is there, you're good. So do file as early as possible. The reason we tell you to file is the EAD expires and they're taking a long time to extend the EAD and H4. So you don't want to lose a job, have a gaps of employment, because when there is a gap in employment, the employer may pick another employer and you may lose a complete job there. So we strongly recommend to file it as early as possible.
James from the X says if someone's L1 is pending and her husband's L2 is currently pending, but the I-94 is expired, can he use automatic visa revalidation process once the L1 is approved? No, the L2 I-94 is expired. That means automatic visa revalidation is not possible. It requires that you already have a valid I-94 to return to. So that would not work in that situation. You'll have to wait for the L2 to be approved or exit and go for L2 visa stamping, which we would not generally recommend.
H1b picked up in March 2025, waiting for visa slots. Does 100K apply if I travel to USA once visa is approved? No, in your case, the visa was filed before the ordinance came in. So before the executive order came in. So the H1B was been filed. So $100,000 is not applicable for you.
HGM says, my priority date is 2016, but I'm not with my current employer. Please suggest. Well, you need to start talking to your current employer about starting the green card process because the perm process and I-140 is taking almost 2 years to make it through all of that. You could also look into going back to your old employer that does have your valid I-140 approval. If that's not an option, you can look into self-sponsoring options, EB2 NIW, EB1A extraordinary ability, EB5 is the only option that is current, and you don't need an employer to sponsor those for you.
Prior to date, there is a chance of movement of prior to date, guys, but we cannot tell it with an assurance that, okay, it's going to be moved or not. But what I can tell you is that if my prior to date is in 2015 or 2016, I'm not going to change the job right now, because if I change the job, I have to refile the entire labor and I-140. That's taking a long time. I may miss the window of filing the opportunity. But don't quote me on this, because you may say that, hi, I lost a big opportunity because what Rahul said. I never said anything to you. I'm just telling what I would do if I were you. I never said anything what you should do. Is H1?
Dinesh says, can you please explain the $100,000 fee if someone has an approved visa and visa stamped, but changed the company and is not in the US? They're Canadian, they're in Canada for the last 6 months. That is a gray area that USCIS doesn't even know the answer to. I've seen so many people that have the visa stamped, but were outside the US, had to file a consular processing H1B, and they are just on hold because USCIS does not know whether the $100,000 fee applies or not. Now, they're not telling you that's why they're on hold, but I've not seen any approvals. Even with premium processing, they're going beyond the 15 business day timeframe. My guess is USCIS doesn't know, and they're waiting for guidance from somebody before they decide how they're going to handle those cases.
Question: is it worth going for the premium processing extension? Yes, it's definitely though, because I want, let's say, for example, your H1B is expiring in September of 2026. If you file an extension right now, and let's say in October, they decide to deny your H1B, and you have to go outside the country, and the $100,000 is applicable for you to come back into United States because your I-94 expired. You can't change the company, you can't exchange, you can extend the H1B at that point of time. But what if the denial comes in August itself? Then at that point of time, you can do one thing. You can refile the extension with the same company, transfer to a different company, transfer to a different visa status, change to F1, change to H4, or any other visa status. So it gives a window of opportunity. So under the unstable conditions that we have right now, it's worth for you to go premium processing, get the result before the I-94 expires. I also advise right now, though, if you're transferring from company A to company B, though, it probably is worth for you to get the premium processing done. The reason is that if you get the denial, though, at that point of time, you may or may not be given 60-day grace period because your H1B is not approved with that particular company. You already left the previous company a long time ago. So if you are extending the H1B, if you're transferring the H1B, it's definitely worth. If you are filing an amendment, though, depending on how much time that you have left on the original H1B, it's up to you whether you want to get the premium processing. But for extension and transfer, I strongly recommend you do.
Ankit says, I received my green card 1 month ago, but my wife's green card application is still pending. No RFE, no documents required. Please advise. It does happen. We saw it quite a bit in the rush of 2022 approvals where spouses got left behind. You can keep waiting. You can litigate, which we would recommend, or you could file the F2A I-130 for her under the family based. And then if that date becomes current, file the 485 based on that as well and proceed with whichever one happens to get approved fastest. But litigation is probably going to be your best bet.
There is a domestic violence case as the primary applicant. Can I withdraw my spouse's case? No, you cannot withdraw your spouse's case because if you're going to withdraw, you're going to withdraw saying that you're going to sign on his behalf. That's going to be a wrong thing that you can do. Please consult an immigration lawyer. Don't take any action by yourself.
Baxtier says, my H1B change of status has been pending since June 30th, 2025. My company did a service request 3 months ago. There's not been any update. Is it normal? I wouldn't say normal, but it's not uncommon. We also have cases that were filed June 30th, 2025 in last year's lottery that are still pending. Not a ton of them, but they're still there. Best thing to do would be to upgrade to premium processing. If that is not an option, then you or your company just have to keep waiting unless you want to litigate that. But typically, litigation is not that helpful when premium processing is available.
I changed my status from F1 to H1. It's not stamped. Can my husband get a H4? Um, my first question to you is that where is your husband? If the husband is within the United States, let's say he's an F1 or some other visa, he can change the status to H4 without any trouble. If he is in India, the first question that comes is are you already married? Are you planning to get married? If you're already married, you can send your husband to H4 visa stamping because technically speaking about, you don't need to have a H1B stamping for your husband to come back in H4. If your husband is outside, if you're not married and you're planning to get married, then definitely I want you to take a wise decision because there are no appointments available and they're giving hard times for the H1B stamping. So just make sure that you get the advice of the immigration lawyer before you embark on the journey.
Ashwini says, for an H4 kid who just turned 14, when submitting the G325R, do we need to upload any supporting documents? Do we need to submit any kids or parents' documents? No, there's nothing to provide other than filling out the G325R. Once you do that, the child should be scheduled for a biometrics appointment to have their fingerprints taken. So make sure you don't miss that. Sometimes it only gets uploaded in the portal and not mailed to you. So just keep checking for that. But otherwise, nothing else needs to be done in the portal.
What is the wait time for I-130 and 485 approval? We applied in F2A concurrently. Surprisingly, the cases we filed recently, they're getting approved within 3 months. And sometimes we get happy denials. I'm very happy to tell my client your E80 is denied, your advance parole is denied because your green card is approved. The clients are very happy about the denial. There are some cases that were filed long time ago that are pending, but the cases filed recently, they're getting adjudicated very fast. The cases that we filed about a year ago are still pending, but the cases that we filed recently got approved.
SW Panikaj says, my H1B was picked in March 2025, waiting for visa slots in India. Is the $100,000 fee applicable if I travel to the US once the visa is approved? No, that fee is only applicable to petitions filed on or after September 21st, 2025. So if you were selected in last year's lottery, you would have filed before June 30th, 2025. So it is not applicable.
Kaja has this question. He filed an EB2 or EB3, and then now his role has changed. Can he file an EB1? He's an L1. Any issues of filing? Just because you previously filed an EB2 or EB3, that doesn't prohibit you to filing under EB1 right now. If you're eligible for EB1 and you're now promoted, you have the EB1C capability, yes, they can file it. Absolutely not a problem.
Pradeep says in a tier two officer called received, the officer said a visa is not available. He says, have all the available visa numbers been exhausted already? No, they have not. They do make those announcements typically, or we find out about them through litigation. It would be very unusual for that to happen in April, especially when they moved the priority dates forward so much in April. So I think they're using that case remains pending um, as telling that a visa was not available, but it might be now if your date has become current. It's just they haven't done anything since they put that case remains pending status.
Do you recommend carrying 797 copy with documentation while traveling domestically? This is a very tough question, though. If you're traveling to some cities like McAllen, San Diego, or some border cities, though, we strongly recommend to carry the original, though. Recently, there was one lady that traveled to a border town and she was trying to fly back into United States. She had only a copy of the approval, and they say they can't verify it, and they detained her for a while, for a couple of days. So I definitely recommend if you go to the border town, or if you're going to, let's say, for example, Puerto Rico, Hawaii, or something, definitely carry the original I-797 approval, though. I would probably, if I'm traveling on flight anywhere, I would definitely carry the I-797 original approval. And if you're traveling to Corpus Christi or any border towns like that, especially the Corpus Christi, there are a lot of people, they travel to Corpus Christi, and there is a check post in between and they don't see the original, they may detain you. So definitely if you go to those border town, even if you're driving, take the original I-797 approval.
SJP says, is H1B premium processing necessary? How long does it take to adjudicate without it? I think right now, normal processing time is posted as 7 months. You can only file 6 months in advance. So that would suggest that your I-94 is going to expire while it's pending for 7 months. And while it's not legally necessary for you to do premium processing because you are authorized to continue working for up to 240 days. You're lawfully present. You're post-bag period of stay authorized by the Attorney General during that time. Is it a very good, very, very, very good idea to premium process your H-1B extension? Absolutely. Even if the company's not paying for it, I think you should pay for it and get it done.
People are asking question about this Dignity Act, and this allows people who are staying illegally in this country to get a 7-year dignity program. And later on, there are under certain conditions could be eligible for maybe green card, but it's not clear. That they say no citizenship but green card. I don't know how that's going to work, but I'll tell you one thing though, very unlikely this bill is going to be passed under the political circumstances we are in. So I definitely would not like to spend my energy on writing letters to the congressmen and senators at this point of time for this Dignity Act.
I think we are out of time for today. Thanks everyone for joining us. We will be back next week, Tuesday at 5 o'clock Central Time. In the meantime, if you want to set up a consultation with us or any of our attorneys, you can go to rnlawgroup.com.
Thank you very much.